was also not audible at all.
Hi, am I audible?
Yeah, you're audible.
Yeah.
Can we start?
So, with your permission, may we begin?
Yeah, I'm waiting since for the past 10 minutes. Please start. Your screen is very easy.
Yes, sir. A very good morning to the esteemed guests and participants. I, Advocate Atuthi Abhay, extend a warm welcome to each and every one of you for this captivating webinar focusing on intriguing topic of Hindu marriages made in heaven, solemnized on earth and dissolved in abroad, organized by Maharashtra National Law University, Mumbai. I am delighted to inform you that this virtual conference space has attracted a diverse audience, including legal professionals, educators, members of civil society, and our beloved law students. As a matter of courtesy, we kindly request all the attendees to mute their microphones during the session. Moreover, we highly encourage everyone to keep their cameras turned on to foster an interactive atmosphere. In addition, I would also encourage our participants to jot down their question and answers to submit them to our resource persons, as we will be conducting a question and answer session at the conclusion of the event. In brief, I would like to talk about our organizers. Maharashtra National Law University, Mumbai, established in 2014, stands as a distinguished institution amongst India's national law universities. Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of the Supreme Court of India, serves as the university's chancellor. His role extends beyond guidance as he infuses the institution with his innovative ideas and extensive expertise in the field of law. Heading the institution is the esteemed Vice Chancellor, Professor Dr. Dilip Uke, a renowned academician in the realm of law, possessing diverse teaching and research experience. His leadership is truly luminous. Additionally, MNLU's Registrar Professor Dr. Anil G. Vadir, who brings a wealth of administrative and legal practice experience to the table. This webinar is conducted in partnership with MNLU's Center for Clinical Legal Education, a devoted entity that consistently endeavors to impart skills of advocacy, legal services, and law reform. Their mission serves as a catalyst for all of us, fostering societal transformation and advancing overall development of the legal landscape. Let us join forces to expedite the sharing of ideas and the expansion of commendable initiatives. I am confident that you will encounter innovative concepts, revitalizing enthusiasm. Without any more delay, I am pleased to introduce to our distinguished resource person for today, Advocate Anil Malhotra. Sir is a highly experienced advocate based in Chandigarh, India, with a legal career spanning over 4 decades. He's earned his Bachelor of Laws and Bachelor of Science from Punjab University, Chandigarh, followed by an LLM from the University of London. His legal expertise covers diverse areas, including civil, service, company, matrimonial, and more, including high courts across India and the Supreme Court of India. He also was a former part-time lecturer at the Punjab University. Anil sir has represented private clients, participated in significant legal reform initiatives, and has acted as amicus curiae. His international work involves providing expert reports in foreign courts, primarily dealing with cases related to non resident Indians, that is, NRIs. As an author, he's co authored books titled Acting for NRI Clients, and amongst others are Indians, NRIs, and the Law, and Surrogacy in India, A Law in the Making, The Removed Child and the Law in India, and several others. He has contributed to international journals too. His dedication to family law and advocacy has underscored by his involvement in campaigns for legal reform, including Hague Convention and interparental child abduction in 1980 and surrogacy laws in India. Malhotra sir's vast experience and commitment have left a lasting impact on the legal landscape nationally and internationally. I am sure after hearing to all this, y'all are eager to hear the insights of this interesting topic from Anil sir. Over to you, sir.
Thank you very much. I am indebted to the Maharashtra National Law University and the Maharashtra Bar for hosting me for this event on a topic which is very engaging, very significant, and is becoming a matter of great concern, not only among Indians, but for over 30 million Indians who live in more than 100 countries abroad and over in India, spread over to 3.28 million square kilometers across 29 states and 10 union territories, which have interactions with people who marry. Now, the topic which I have coined is marriages made in heaven, solemnized on earth, and dissolved abroad. A quandary. Now, why do I say so? To understand the situation, let us consider a very hypothetical situation. We, as a majority population in India, are Hindus by religion. And the Hindu definition means any person who's a Hindu is a person who's a Sikh, a Buddhist, a Hindu is considered to be a Hindu. Now, the peculiar characteristic of this personal law application is that whether you go to Germany, whether you go to America, whether you go to Australia, or whether you go to Canada, and whether you become a citizen of any country, British citizen, European citizen, American citizen, or Italian citizen, you always still remain a Hindu. Your Hindu religion does not go away. Till, of course, you consciously decide to call yourself a Christian or a Muslim by an appropriate measure of conversion, not a decoy or a fraudulent method. So where do we get this? We get it in section 1 and 2 of the Hindu Marriage Act. Now, the provisions of the Hindu Marriage Act say that it shall apply to all Hindus and shall extend to territories beyond India where such Hindus reside. So, put it in a nutshell, the Hindu Marriage Act has extraterritorial application, meaning thereby that if you marry under Hindu law, you will carry your Hindu marriage with you wherever you go and whatever you do. A lot of people do a civil ceremony according to laws of foreign countries and add on to the marriage. Let us get our basics clear in the first instance. A marriage under Hindu law is a sacrament. It has a holy status. It has a sacramental value. It has the makings of something which puts a family together and it is revered and respected. But the moment you travel outside India, you go to Europe, America, Canada, Australia. Now, in these countries, marriage is a contract. So this is where the basic distinction comes in. In India, we try to save the marriage. In overseas jurisdictions, dissolving a marriage is for the asking. So this very basic distinction of a marriage being in the nature of a sacrament and in the nature of a contract is what makes the marriage different. So the Hindu marriage is a sacrament which we carry with us abroad. And if we solemnize another marriage under the laws of that country, by virtue of the fact that we are domiciled there, and by virtue of the fact that we want to gain citizenship of that country, that additional marriage ceremony, civil ceremony, which we do, may be a contractual ceremony. So now coming back to our Hindu marriage, now the law is very clear. It was first so stated in the celebrated case of Y. Narasimha Rao. This was in 1991 by the Supreme Court. And Supreme Court said very clearly, relying on section 13 of the CPC, that Hindu marriages, I'm only giving you a nutshell, Hindu marriages solemnized on Indian grounds according to Hindu law can only be dissolved by a court of competent jurisdiction under the Hindu Marriage Act or the Family Courts Act. Now, the test stone or the mandatory provision for testing the validity of a foreign judgment is in section 13 and 14 of the Code of Civil Procedure. Now, section 13 of the Code of Civil Procedure says when a foreign judgment is not conclusive. So, section 13 says a foreign judgment shall be conclusive of any matter adjudicated between parties except. So there are 6 exceptions to this rule. First, where it has not been pronounced by a court of competent jurisdiction. 2, where it has not been given on the merits of the case. 3, where it appears to be on the face of the proceedings founded to be on an incorrect view of international law or is refusal to recognize the law of India in which the law is applicable. 4, where the proceedings in which the judgment was obtained are opposed to natural justice. 5, where it was obtained by fraud. And 6, when it sustains on a claim founded on a breach of any law for the time being in force in India. Now, the bottom line is any judgment obtained from a foreign court on a ground not available under Hindu law will fall foul of section 13. Now, in first coming to divorce in our jurisdiction, we have as many as 10 or 12 grounds for divorce under section 13 of the Hindu Marriage Act. Likewise, under the Special Marriage Act. So, these are fault grounds. So, you have to allege cruelty, desertion, adultery, and the host of many other grounds, and then you have to prove and establish them in a contest before the family court or the district judge, as the case may be, by pleadings, coining of issues, leading of evidence, and then a judgment coming forth. That is the procedure laid down in the Family Courts Act. Now, we also have additionally in section 13b, divorce by mutual consent, where two people can go to the court and say, we have been living apart for a year, we can't stay together. The court adjourns the matter on the first motion for 6 months. You come back after 6 months, court passes the second motion and you're divorced. Now, what is most important to realize here is that we do not recognize irretrievable breakdown of marriage in India as a ground for divorce. Because irretrievable breakdown of marriage is not one of the grounds mentioned in section 13 of the Hindu Marriage Act. Now, I may hasten to add here that the Supreme Court, at the end of the litigation, when all means are exhausted, uses its residuary power under Article 142. Now, Article 142 is a residuary power of the Supreme Court to dissolve a marriage or to grant any relief in any matter, in any case, to do complete justice to parties. So, Supreme Court sometimes uses this phrase irretrievable breakdown of marriage and grants relief under Section 142 of the Article 142 of the Constitution. But that is the power reserved to Supreme Court, and it is not available to any other court in India. So, whenever we see a marriage solemnized in India, which is dissolved by consent of parties against consent of one party, or by force, by fraud, or in the absence of one party, on irretrievable breakdown of marriage, that divorce decree is considered to be no good or not effective, or a judgment which is not conclusive in terms of section 13 of the CPC. Now, what is the status then? You are divorced abroad, but you are married in India. In Satya versus Teja Singh, Supreme Court in 1975 said that these marriages of such status are called limping marriages, which means you are split in one jurisdiction, but you are married in the other, and there is no resolution. Now, what happens abroad? Now, since in foreign jurisdictions all over the world, practically, marriage is a contract. Marriage is a partnership, civil status partnership. If you wish to divorce and you go to a court and you say, I want to divorce, they will not ask you more questions. They will grant you an irretrievable breakdown of decree of divorce on your asking. And they will confirm the decree once you settle child custody and other remaining issues of matrimony, of maintenance and settlement of matrimonial property. Now, no other country's laws treats marriage as a sacrament, and therefore, for them to dissolve the marriage as a contractual union on reasons of breakdown of marriage is a normal, civil, and the only course. But when we as Indians agree to do this, and one party decides to go against or change, then if that decree is sought to be enforced in India, then there is a problem, because that decree of divorce is not recognized. And there is no way by which you can apply for it to be recognized or you can get it converted to be recognized. There is no way. The only way to get a divorce in India is afresh on a new petition before a court of competent jurisdiction in India. You can apply to a court where the parties got married. where the parties last resided together, or where the wife lives if she's living in India. So, what is the way out which I suggest to people is that if you have a decree of divorce or irretrievable breakdown and you wish to put an end to your matrimonial litigation, because in India, a matrimonial litigation means a separate petition for child custody, a separate petition maybe for maintenance under 125 CRPC, a domestic violence case, a FIR under section 406, breach of trust, section 498A, matrimonial cruelty, and section 3 and 4 of the Dowry Prohibition Act. Then an anti-injunction suit. So there may be various litigations pending in India which will not be closed by virtue of a foreign court decree, simply for the reason that that decree of divorce is not valid in India. So the way out is both parties agree, draw up a settlement, mention in the settlement that they've already got a divorce in that jurisdiction abroad, give a joint consent to being divorced in India, and apply for mutual divorce by mutual consent in India. They needn't come here physically. They can appoint a relative, friend, family member, etc., as a nominee or a power of attorney holder who can appear online and identify them. That relative or POA holder can appear in the court. The court can view the litigants online abroad and identify them by their passports, and the POA identifying them too. The judge can record the consent of both sides, adjourn the matter for 6 months, or if he thinks no useful purpose is served, grant a decree of divorce. So this process has been simplified for the simple reason that people should not be left hanging in what were known as limping marriages, so as to the marriages not being dissolved in India if they were dissolved abroad. Now, why do people resort to this abroad? The answer is simple. Everybody thinks that in India it is going to take a lot of time. It's going to involve a lot of resources. It will involve a lot of hearings. It will mean a lot of dates, and the agony will be multiplied. So the answer to that is very simple, that people abroad need to be educated that there is a simplified method of applying for divorce by mutual consent in India. All you have to do is get proper legal assistance in the place where you wish to seek the divorce. Talk to your opposite counsel. Talk to you through your to your spouse through your counsels abroad. Take the assistance of an Indian lawyer. You can have one lawyer for the mutual consent petition. You can have two. You can have one. Draw up a petition. Do a civilized divorce in India. That divorce in India will finish the FIR for matrimonial cruelty and dowry, will finish the maintenance proceedings, will finish the child custody proceedings, will finish all other litigation. Because you will record a comprehensive settlement on all these issues, and you will also agree to withdraw everything in all other courts. And that settlement which you arrive at will be taken note of by the judge, and he will, after confirming from you, that is both sides, pass a judgment for divorce by mutual consent and draw up a decree. So people rush into a foreign divorce without realizing that what they are going to do is not going to buy them the peace in India. So if you have a foreign divorce decree, it will not finish the FIR. It will not finish the child custody. It will not finish any other proceeding in any other part in India in any other court. It may have persuasive value, but it will not be conclusive. So it is not an advisable method to jump into a foreign divorce and then realize that there is still a problem in India. And another thing, if with the foreign divorce decree you marry in India, you are guilty of bigamy, which is a criminal offense under the Indian Penal Code. So you, from the frying pan, you'll go into the fire. And your marriage, second marriage can be wrecked by the simple reason that you were not advised properly. Now, the law in this respect came for the first time in 1991 in Y. Narasimha Rao versus Venkata Lakshmi, where the Supreme Court said, repeating what Section 13 of the CPC says, and they said that only Indian courts can dissolve Indian marriages in such circumstances. Now, I happen to assist our High Court as an amicus in a case called Rupak Rathi versus Anita Chaudhary, which is reported as 2014-2 HLR 96. 2014-2 HLR 96 Punjab and Haryana. Now, since there was some confusion in this judgment of the Supreme Court, I assisted the court in giving clarity and watering down the Supreme Court judgment with explaining the exceptions as had been explained by the Supreme Court. Now, Rupak Rathi versus Anita Chaudhary was a case of a couple who had married in the northern state of Haryana, had shifted to England, had participated in a divorce by irretrievable breakdown in England, and the lady had come and sued the husband for a divorce decree in again afresh on grounds of cruelty in the northern city of Panchkula, northern town of Panchkula in Haryana. Now the husband came up in a objection petition under Order 7, Rule 11 CPC saying there was already a divorce. Why another divorce? And the court said no, this can't happen. That divorce decree you have got is not good. Now the husband came up in a revision petition before the High Court, and in the High Court it was held that no decree of divorce obtained from an English court on a ground not available under Hindu Marriage Act can be sustained if it is on the ground of irretrievable breakdown of marriage. Second, where parties were agreed to confer to jurisdiction in the foreign court, that court will assume jurisdiction available to the matrimonial court in India, but it will remain confined to adjudicate the action in accordance with the matrimonial law of the parties, the Hindu Marriage Act, and the ground available therein. So, if you want to give a court in abroad to decide your matter, then the court has to do it on the grounds available under the Hindu Marriage Act. And obviously, no court abroad will do this for you. Then the third, the legal position is that when a Hindu couple tied by the nuptial knot according to Hindu rites travels abroad with the intention to settle down abroad and reside there to set up a matrimonial home, they carry their personal laws on their back and which they offload on a foreign court for adjudication. So you're approaching the foreign court for adjudication simply on the ground that your marriage is broken down is not going to get you any relief in India. So such like limping marriages put the status in a quandary. The worst situation is when there are children, because there are custody rights, and if those custody rights are sought to be implemented in India, particularly when the children are in India and the foreign decree has been passed abroad, there is a lot of difficulty in implementation. And if you bring a foreign court decree for implementation in India, any family court judge will say, I don't agree with it. So you may have to start all over again. So it is in this scenario that the multiplying number of litigations have led to another breed of litigation called anti-injunction suits. Now, what are anti-injunction suits? Now, anti-injunction suits are litigations between parties in two different jurisdictions on the same list, the same dispute, for the same relief, proceeding parallel. So let us suppose you have one child custody petition in the US and one in India, or one divorce petition in England and one in India, seeking the same relief going simultaneously. You can seek the relief, let us say in India, of seeking to stop the opposite party, not the court abroad, from proceeding with the matter because it is more convenient, it is more practical, and it is more reasonable to decide the litigation in India. So, this commercial law concept of anti-injunction suits emerges from the principle of forum of non-convenience. So, which simply means that whichever is a convenient jurisdiction for both the parties on the same issue for settlement of the same dispute, then only one court should decide the matter to avoid multiplicity of litigation. So effectively, when you file an anti-injunction suit, you seek to restrain the opposite party before, let us say, the Indian court. And you ask the Indian court to stop the opposite party from proceeding on the same dispute before the court abroad. It is a difficult injunction to get, but it is a new age litigation which is emerging from commercial litigation to family law litigation in such situations. Now, the worst thing of offshoots of limping marriages is inter-country, interparental child abduction. So whenever one spouse fears that he is going to lose custody because there is a breakdown divorce decree abroad and the children will be taken away, the spouse gets on a plane, picks up the passports and comes back to India. And what do we do in India? We do nothing. Because under Indian law, inter-country, interparental child removal is not an offense. So if you pick up your child from a foreign country and bring him or her to India, violating your other parents' rights or violating a foreign court order, under Indian law, you have done no wrong. Because under Hindu law, you are a natural guardian and you have equal parental rights over the child in as much as the other parent has in India. So the remedy under such a situation is a writ of habeas corpus. Now this is an extraordinary remedy under Article 226 of the Constitution of India for securing the release of a child from the custody of the custodial parent under the parent's portray, that is the welfare jurisdiction of the court, the High Court under 226, Supreme Court under 32, and sending the child back to the country of its habitual residence on the ground that the jurisdiction of closest contact should decide the welfare of the child. And the consistent law has been that the High Court in a summary or a detailed hearing can take a call and decide what to do. They may return the child back to the country from where the child came, or the child has lived for very long and there is consent, send you to the family court in India for deciding. And there is no hard and fast rule, and the Supreme Court keeps changing its views. But for some time, the views have been consistent that a child removed from a foreign country should go back. And if the offending parent is not interested in going back, then the court says, okay, you hand over the children and you stay back in India. So this has been a developmental jurisdictional jurisprudence which has come forth in this situation and is an offshoot of limping marriages. Now, another very subtle thing which has come about is that there are instances where spouses are spouses fear coming back because of being arrested in domestic violence cases, in dowry cases, in matrimonial cruelty cases. Now, this is again an offshoot of the limping marriages situation. Now, any spouse who is aggrieved by a foreign divorce decree and can't challenge it because of limited financial resources, because of being unable to engage a lawyer in that country, or because of no visa to go to that country, will use all these remedies to bring the other side to India. Now, all this put together brings you to a situation where I have used the word quandary, meaning a mess. We are looking forward to reforming so much in our laws. Our arbitration laws, which fetch money, have been amended so many times. We have thought of a uniform civil code. We haven't got one as yet. Goa is the only state in India which has the Portuguese code as the uniform civil code, and everybody follows it. But that does not happen in the rest of the states in India. Personal law is what decides everything. And since majority of us are Hindus, we follow the mandate of Hindu law and whatever the Supreme Court has to say about the interpretation of Hindu law. So in this situation and backdrop, for a marriage which is finished, which is broken down, my best possible suggestion and recommendation to persons is you must decide how to dissolve the marriage in India. If you are married in the country of that the place where you reside, and you have a civil marriage or a marriage in that jurisdiction, you dissolve the marriage which you have performed in the foreign country according to the foreign laws of that country. But insofar your marriage in India is concerned, you have to dissolve the marriage in accordance with the divorce by mutual consent, if not by the fault ground under Section 13. So instead of trying to enforce the decree or getting the decree recognized in one way or the other, the best way is to file a petition for divorce by mutual consent in India, put on record your foreign divorce decree, put on record your settlement, appear before a court, online or physically, and say, please dissolve my marriage. It's not a very difficult task, but then that's the only way out. Now, this is where people don't get proper guidance or people don't want to take help. Some people just rely on what is available on the internet. And people think, well, I've got divorced where I live, so I'm not bothered. But you ought to be bothered. Why? Suppose you are paying alimony in a foreign country. You are settling maintenance claims. You are dividing property. You are dividing assets in the foreign country. If you don't dissolve the marriage in India, your FIR for cruelty, harassment, dowry your child custody petition, the claim for return of dowry will remain alive. So it is not in your interest to leave financial claims open and divorce abroad by giving the alimony without realizing that it will not close the Indian cases. So before you pay, this is what I advise most of my clients who divorce abroad. I said, you get a divorce by mutual consent, sorry, on breakdown grounds, get a decree nisi, don't get a decree absolute, settle the matter in India, pay the money in India, do a divorce by mutual consent, have all the cases withdrawn or quashed in India, and then pay the money in the US. So this is the practical solution which I advise to most of my people as being the reasonable answer for dissolving such marriages. Now the issue is, why can't we take care of this in advance? In most countries abroad, people enter into prenuptial agreements or postnuptial agreements. Now, in most countries abroad, prenuptials and postnuptials are allowed for the simple reason that the marriage in that jurisdiction is a contract. So, before you enter into a contract, you can draw up an agreement to decide that if the contract is terminated, what is going to be the aftermath. Now, since our marriage in India has the halo of ceremony, of sacrament, and of religious feelings, thinking of a prenuptial agreement would be an antithesis to the very philosophy of a Hindu marriage. Because people might think you're crazy if you're talking of separation before marriage. So that psychological mindset of the sacrament makes a prenuptial agreement illegal, and it is void ab initio under the provisions of the Indian Contract Act as being wholly tenable, as being wholly untenable under Indian law. But still, a lot of couples who are involved in high-tech jobs in the IT sector and who are going to live abroad and who do not wish to have problems, they dissolve their marriage. They do a prenuptial agreement before they go abroad, for the simple reason that it helps them to resolve their differences once there is a split. Now, that being so, in India, for prenuptials to be entertained or written down are violative of the Indian Contract Act because they are against public policy. Since marriage is a sacrament, not a contract, so any prenuptial agreement entered into between parties will be straight away a contract which is null and void. So you may not be able to enforce it abroad, though if there is a consent of the parties and nobody raises an objection, you may still get away with it, and you may be able to enforce it. Because if you're parting in a civilized way, you might as well do it. Now, another very important fallout of limping marriages is people who have gone abroad in the early 60s or 70s and who have accumulated huge wealth in India and abroad. Now, when they want to divorce, let us say they are agreeing to divorce abroad, they divide their assets. Who gets the yacht, who gets the villa, who gets the farmhouses in India, and so on and so forth. Now, this irretrievable breakdown divorce decree entered into or decided or given by a foreign court in an overseas country will not help you to change names of land records, mutations, or property holdings registers in India. No authority in Indian law will accept a foreign court divorce decree for changing names of ownership or changing land records or changing urban records of ownership of property. So you will again be facing a stumbling block. But if you have a straightforward Indian divorce decree given by a court of matrimonial jurisdiction under the Hindu Marriage Act, then of course you will be able to immediately seek a change of names of the ownership of the property. If you have divorced and arrived at a settlement that this property will go in so many shares, or this property will not be divided, or this property will be split or transferred into so and so's name. So this is another fallout I've seen in the case of people with a lot of assets, but who have still retained or bought sizable assets in India, and who on divorce find it very difficult to seek transfer of these properties based on the settlement which has been arrived at. Because in India, if you don't follow the Indian law, the properties will go by succession, which means all legal heirs get an equal share. So if there is a share of a spouse by virtue of a divorce decree abroad, that fails into insignificance because the foreign court divorce decree is not recognized as a valid divorce ground under the jurisdiction of the Indian courts. Now, another fallout is inheritance. Now, if you divorce abroad, don't divorce in India, and you pass away, thinking that on divorce you have already divided the assets on divorce in the foreign country, that divorce decree for purposes of succession in India will not be of any use. And all property in India will devolve on the successors by the provisions of the Hindu Succession Act or the Indian Succession Act, or by a will if the person owning the property has left a will. So this is again confusion confounded for the simple reason that a proper legal remedy was not adopted and issues remain pending. Then is child custody. Now, if you wish to seek to enforce an order of child custody arrived at by a foreign divorce decree on breakdown in a foreign court in India, the family court will say, we'll look at it again. We will not rubber stamp it. Because under the Family Courts Act, the district court, that is the family court, has the jurisdiction to decide all matters related to marriage, divorce, adoption, abduction, guardianship, etc., etc. No foreign court divorce decree can usurp or abdicate to itself the divorce jurisdiction or the prerogative of divorce under Hindu law to itself. So the bottom line of all this is, if you marry under Hindu law, you have to get divorced under Hindu law. Now, another confusion which prevails for foreign court judges is two different dates of marriage in India. Now, under the Hindu Marriage Act, all we need to do is a ceremony. Section 7 says do a ceremony, that's all. It may be the Saptapati, 7 trips around the fire, or it may be Anand Karaj, the Sikh religion way, or any other way of ceremonial marriage under the Hindu Marriage Act. Now, beyond ceremony, Hindu Marriage Act says nothing is necessary. But under the Special Marriage Act, there is a provision for getting your ceremonial marriage registered. So under Section 15 of the Special Marriage Act, you can register your marriage solemnized and celebrated in other forms. So you go to the registrar of marriages and say, I married in 1968. I am now coming in 2024 because I need to travel abroad. I need to show my marital status. So please register my marriage and give me a marriage certificate. He'll do it. But he will not change the date of your marriage. That date of marriage of 1968 will remain. He will give you a date of registration of the marriage. So you will get a certificate of marriage which will permit you to prove that you are married, which will permit you to get a visa to travel abroad, and will permit you the facility of having proof of marriage. Now, this marriage certificate is the ceremonial marriage certificate. But under the Special Marriage Act, under Section 5, you can straight away register your marriage. So you don't solemnize your marriage under the Hindu Marriage Act. You may be Hindus by religion, you may be Muslims, Christians, or anybody. Any two persons can marry under the Special Marriage Act. Persons means obviously persons of opposite sex. So irrespective of the fact that you are Hindu, Christian, Jew, Muslim, Parsi, you can marry under the Special Marriage Act, for which there is no ceremony required, for which registration is essential. So that is the second mode of marriage which you can entertain into by performing a registered marriage, or as you may call it. So you go and sign the marriage register. It is put up for objection on a public notice board, and then after 30 days, you are issued a marriage certificate. So if you have a marriage certificate of that kind, that will be a contractual marriage, not a ceremonial marriage. That kind of marriage can be dissolved abroad. But a Hindu marriage, whether registered or unregistered, will still, status will remain same, and it cannot be touched by any court in a foreign jurisdiction. If a foreign court does touch it and dissolves it, it only gives you a divorce status abroad. In India, you remain what I call is in a country. So this is the long and short of the entire thing. Now, I will leave the floor open for questions, and you can put them up one by one. You can unmute the question speaker, and I will answer the question straight away.
Thank you for such an insight. My participants have posted their message on the chat box. There's one question which I would like to read out. That is, if one partner has got a decree in foreign court of divorce wherein the other partner has appeared on one date and given her reply under protest, and thereafter she hasn't appeared in the foreign court and an order of divorce is passed ex parte, will it be considered by Indian courts?
See, the answer is very simple. The unwilling partner, spouse appears in the foreign court, protests, and says, I am not going to admit to the jurisdiction of the court. The foreign court says, you are in my territory, you are domiciled there. I don't care whether you're a Hindu, Muslim, Jew, Parsi, or whatever. You are a person who are domiciled in my territory, so I have jurisdiction over you. And he disregards your objection and proceeds. So there is an ex parte decree on divorce. Now, this ex parte decree of divorce under Section 13, on a ground of law, which is not acceptable under Indian law, is invalid. So if you come to India, the Indian court will throw that decree in the dustbin and say, please file another petition. Next.
Yeah. So the next question is, what if the decree of divorce obtained in a foreign court meets the valid conditions for divorce under Hindu Marriage Act, then will the Indian Family Court accept such a decree? And what happens
About asset settlement and child custody in India?
about the asset settlement and child custody in India?
You see, I have never seen a judgment of a foreign court deciding a divorce petition on grounds of adultery or cruelty or desertion on merits. It is a thing of the unknown. But let us suppose hypothetically there is one. And all the 6 exceptions of the provisions of section 13 CPC are not applicable. Then the divorce decree will be valid. But the point is, you will still have to come to the family court in India and seek its implementation. You can't just walk around with it and say, oh, give me this, give me that. You will still need an order of an Indian court, maybe the civil court or the family court, to execute that foreign court decree. So execution might be another round of litigation in India to enforce the decree of the foreign court. Next, please. Next. So if marriage is of a person who is married under, you want to read out? So is divorce by a person who is married under Christian Marriage Act or any other marriage can act apart from Hindu Marriage Act abroad valid in India? Christian Marriage Act or any other marriage. Just a moment, let me just read this. So is a divorce by a person who is married under the Christian Marriage Act or any other marriage act apart from Hindu Marriage Act abroad valid in India? Yes, if a person is married under the Christian Marriage Act. Now, under the Christian Marriage Act, again, I think there is a registration requirement, but under the Indian Divorce Act, I think 1869, there is none. So, if there is a non-Hindu divorce, uh, non-Hindu marriage on Christian law or any other foreign law, then that kind of a divorce decree can be made applicable in India. But again, it has to be executed in India in the Family Courts Act. Now, if both parties are in foreign court and they are Christian by religion, and husband has filed divorce petition in India, as marriage is solemnized in India, but they are already but they are ready for mutual divorce. But they're ready for mutual divorce, but issues pertaining to money. Wife was alimony in Oman currency and she is in Nam, while husband is in Dubai. Then in which mode of money transaction will be done? I think the Indian court will decide in Indian rupees, unless you are able to satisfy the court that the that you are entitled to be given maintenance in the way in which you were treated when you were married. So if you are enjoying a marital status in a country abroad, your husband is entitled to maintain you in the same way in which you were being treated prior to marriage. And if that requires currency to be given in dirhams or the currency of that country, then you need to get compensation according to the standards of that country and living lifestyle of the country which you were being treated to before you got divorced. So every divorce granted in foreign court, it was suggested to take divorce 30B. What if one spouse does not cooperate? See, if the other spouse doesn't cooperate, then there can't be a divorce by mutual consent. Then you have to fall back on the fault grounds. There is no other way. See, both parties have to agree unanimously, not in the first stage, in the second stage also, for a divorce decree to become enforceable. Sir, nowadays it is seen that couples first get married under the Special Marriage Act for visa purposes, then under Hindu Marriage Act, and then after going to a foreign country, they also get married as per their law. In such cases, how do we proceed to resolve this marriage? Three marriages. So the first marriage is done under the Special Marriage Act for visa. Now, when people marry and just for the visa, the marriage is not consummated. It is just a contractual marriage. This marriage under the Special Marriage Act can be dissolved in India under the Special Marriage Act because this is not a ceremonial marriage. So Special Marriage Act has grounds for divorce, and you can dissolve the marriage there according to the provisions of the Special Marriage Act. You can dissolve it by mutual consent under the Special Marriage Act. Then the second marriage is under the Hindu Marriage Act. Now that I have already told you can only be dissolved under the Hindu Marriage Act, under the grounds in section 13 before the family code in India. Then third marriage is they also get married as per the law of that foreign country. That marriage will be dissolved according to the law of that country in which you got married. So the more marriages you perform, the more divorces you'll have to obtain is the simple answer. Then, sir, I have differences in my marriage. We are in a marital conflict for the past 1 year. And I have two 10-year-old kids. Wife is now working on how to file for divorce, breakdown, retrieval, or retrieval breakdown, or cruelty. Can I stay in another house but still maintain family? No hopes of mutual divorce. So, yes, you can separate. In fact, you can take a degree of judicial separation also. So, this is a lesser evil than divorce. You can live apart by consent or by mutual agreement. You can file a divorce on grounds of cruelty. And if somewhere down the stage the other party agrees, you can convert that petition to one for irretrievable breakdown without the necessity of filing another petition. Then next, I had a case wherein both the parties got divorced in Australia, and the wife came in India and filed a case under 498A and complained that the husband forced her to sign the divorce in Australia. Of course, according to the husband, it's a lie. What is to be done in this situation? So this is the problem area. When the parties got divorced in Australia, they should have, and maybe the husband paid alimony. The husband should have filed a divorce by mutual consent in India also, and he should have got divorced in India. And he would have been saved of the 498A, that is matrimonial cruelty. And there would not have been any way for the wife to question the divorce in Australia. But now he is stuck. So he has to maybe file a divorce in India on the grounds of cruelty or adultery or whatever and get a fresh divorce. Otherwise, the 498A will remain. Or he can contest the 498A saying we have got a divorce, but it is for the court to consider what is the value of the divorce in the 498A proceedings. Next. You want to read out any question?
Sir, there's this question about can a nikah be dissolved? E-talaq mubara, that is mutual divorce taken abroad, even if the nikah.
I can't hear you. I can't hear you.
Sir, can you hear me now?
Yeah, I can hear you now.
Yeah. So the question is, I'm curious, can a nikah be dissolved? Talaq-e-mubarak, that is mutual divorce taken abroad, even if the nikah has taken place in India.
Just let me see, where is this? Can a nikah talaq-e mubarak taken abroad, even in cars taken resolved. Yes, you can see under the Family Courts Act, you can go and take a divorce. Muslims are not prevented from going because under the Family Courts Act, there is no bar on person. There is no bar on. There is no bar of religion. Under the Family Courts Act, any person can go and file a divorce petition. Yeah. Next.
Yeah. In the interim stage, when custody is not finally decided, but one parent, say a Hindu mother, with whom child is residing, decides to leave India with the child, with that tantamount to removing a child from the lawful guardianship, applying the fact also that the father is a natural guardian under Section 6 of the Hindu Minority and Guardianship Act, and until the custody is finally decided, court is de facto lawful guardian. And would this tantamount to criminal offense of kidnapping under IPC?
You see, under Section 26 of the Guardian and Wards Act, once a petition is pending, the child cannot be removed from the court or the custody of the jurisdiction of the court to a foreign jurisdiction. Now, the best way to ensure such a situation if there is a risk is that the passport of the child should be deposited in the court. If you don't take that precaution and the child is taken away, it will amount to violation of Section 26. It is unlikely that the police will register a case of kidnapping until and unless the court itself holds that the child has been kidnapped. But then the larger question comes in Section 6 of the Hindu Minority and Guardianship Act. The father and after the natural mother are natural guardians. So this is a very catch-22 situation. And the only remedy is to be careful. If you have a risk, tell the court to take the passport of the child. But if you don't take that precaution, you have to insist before the court there is contempt. You have to insist before the court that there is unlawful removal and the court should be asked to register an FIR. But the court may also reach a conclusion that the child is no more in its jurisdiction and therefore the court can do nothing about it. So it's a very discretionary sort of a situation. Next, any more?
This one will be the last question.
Yeah.
Divorce granted in foreign court. It was suggested to take divorce under Section 13B. What if one spouse does not cooperate?
I just answered this question. I'll repeat it. You have taken a divorce in a foreign court. You want to file a divorce by mutual consent. The other party backs out. You file a divorce under ground of cruelty, saying we are already divorced there. Here is the foreign divorce decree. Please grant me a divorce on the ground of cruelty. So you will have to take a contested divorce petition and get a divorce by contest on other grounds under Section 13. And you can use that foreign divorce decree as evidence and proof that you are only being harassed, treated cruelly, and intimidated.
All right.
That's it.
Thank you so much, sir, for your relevant answers. And I also thank all our attendees for the relevant questions. As we conclude this session, I, Aditi, will now hand over the reins to the driving force of this webinar, our coordinator, Advocate Shraddha Darvi. She has played an instrumental role in planning and coordinating this event to ensure its resounding success. Ma'am, we eagerly wait for your vote of thanks. Shraddha, ma'am. Over to you, ma'am. Shraddha ma'am, are you audible? Do you hear us? Am I audible? Shraddha ma'am, you are not audible. Ma'am, we can't hear you.
We are the Anand.
So I'm genuinely sorry for the interruption. Just give me 1 moment. I'll just check with her.
Yeah, please. My website like blog billing or my blog at.
On behalf of Shraddha ma'am, I would like to extend our hearty vote of thanks to Anil Malhotra sir for remaining present here and accepting our invitation. Extremely thankful to you, sir. I also thank Maharashtra National Law University, Mumbai, Vice Chancellor sir, Anil sir, also Shraddha ma'am, for giving us this platform to have understood about such a wonderful topic. Thank you so much, everyone, for being attentive to the sessions. And I'm sure we'll definitely have some more interactive sessions in future as early as possible. Thank you so much, everyone. Signing off for today. Thank
Thank you
you.
very much. I would just like to add that I have given my website details www.anilmalhotra.co.in and my blogspot address on the chat box. Anybody who's interested in seeing anything more, I have lots of stuff. I have 9 books. I write very frequently. There are a lot of webinars. There is a lot of material. So anybody can visit the uh, website or the blog and can get updated. Thank you very much. All the best. Thank you.
Thank you so much, sir.